Can you hear me?
Yes,
I am fine.
Very clear. Very clear. Nice birthday.
You're welcome.
I am Radian, coordinator of study program of Master of Law and Development. I would like to say thank you very much for your kindness, for your time to give lecture to students and also many, and this is open, and of course everyone can register to join this public lecture. So once again, thank you very much.
Thank you, Radian. Can I start my story?
Wait for 1 minute, please.
Okay.
Yeah, we still waiting for participant to join soon. Yeah.
Okay. I'm very patient, no problem.
Here also join Dr. Rosa.
I see her.
Good afternoon.
Hello, Michael. How are you?
Good to see you, Rosa.
Good to see you also. Thank you so much for your willingness to deliver another public lecture for us.
Always happy to come to Surabaya.
Yes, I hope next year the COVID has already gone, maybe, and we can have you in person. How is it going in Belgium?
It's difficult to say.
Hmm.
Still, I think we still have 2,000 new cases every day. So it's
okay.
Yeah.
So sad, yeah. Is it like a Delta strain or?
Yes.
Okay.
Yes.
Yeah.
But normal life is slowly coming back, very slowly.
Yeah. Here is actually has already reduced the number of contracted COVID-19, but yeah, we don't know because it's like unpredictable, right?
Yes, yes. I think formally Indonesia is still a red zone, I think.
Still high, yeah, still high, but yeah, it's better than 2 months ago, actually, yeah.
Yeah.
It's better than 2 months ago, actually.
Yeah.
Okay, shall we start now, Professor Faure?
Thank you, Pak Radian.
Thank
you.
Sorry. Before you, may I introduce to the public? Sorry. Okay. Good evening here. Selamat malam, all participants, and good afternoon, Professor Michael Faure in Belgium. Today, Master of Law and Development Postgraduate School, Airlangga University, invites Professor Michael Faure. I would say that, of course, he is a very well-known person and expertise in environmental law. Yeah? This is a second public lecture. At the first public lecture, we talked about a disaster, yeah, which is relevant to Indonesian context, of course. Now we have a very interesting topic. Let me say that this is fundamental, but also reflective. And I think Professor Faure also will update development of environmental law and policy for developing countries. We are here in Indonesia you may hear about omnibus law. In Indonesia, one of the issue of the omnibus law is issue concerning environmental law, mining, and etc. So without further ado, Professor Faure, the floor is yours. Thank you.
Thank you very much for this very kind invitation. It is for me always a great pleasure to go to Indonesia. It is now the 31st of August, but when I walk outside here in Belgium, I have to wear a sweater. It is cold, it is raining. I feel like doing Christmas shopping. The weather is so cold. So then having the possibility to go to Surabaya for me this afternoon, for you this evening, makes me very happy. And of course, with you, I hope that we can put this terrible disease behind us shortly and that I could really visit Indonesia again. And I never had the possibility of visiting Airlangga University, but I certainly hope to do so in the future. I have agreed with the organizers that I would talk maybe for 45 minutes approximately, so that we still have sufficient time for some debate and discussion afterwards. And I'm looking forward to that, because the topic that I would just like to have a few reflections, a few thoughts on, is a topic which perfectly fits into the topic of law and development, the Master of Law and Development that Paradian was talking about. See, the question that I'm interested in is, what type of environmental law do we need for developing countries? And for example, but not only, for Indonesia as well. And you know, I have been interested in that question for a couple of years now, because I found it striking that to some extent, we have seen many attempts in developing countries of people with good intentions to protect the environment. All kinds of environmental laws are made. If you look in Southeast Asia, in Africa, in Latin America, you cannot say that there is no environmental law. To the contrary, there is a lot of environmental law, there is a lot of environmental policy, and even stronger, there are international donors, the World Bank, the IMF, that all force countries, including Indonesia, to adapt what they call a modern environmental law as a condition for funding and for development. Still, there is something like a paradox. What is a paradox? You can say that for several decades, we have tried to make an effective environmental law in developing countries. And yet, if we look at what has come out of it, we still see that to a large extent, many of those laws have not been very successful. Of course, it is always dangerous to generalize. And there are undoubtedly some isolated success stories in particular countries. Take a country like Costa Rica that is doing particularly well. And you could give other examples of countries where there are positive developments. But on the whole, what we see is that the amount of environmental pollution in developing countries is still continuing at an alarming pace. And that, of course, raises a little bit the question, what has gone wrong there? How is it possible that we have this paradox? The paradox of, on the one hand, a lot of law on paper. It is not that the law is lacking. And on the other hand, we don't see that the environmental quality as such is increasing. And it is on this paradox that I would like to formulate a few reflections with you, also in the light of the fact that there is an increasing literature that has been examining what could be the causes of this paradox. Why is it possible that we sometimes make environmental law that then by the end of the day does not seem to be very effective? And it is about this type of literature that I would like to talk to you and see if we can draw a few lessons and conclusions. Before doing that, I would like to point you at a literature, an economic literature, that has addressed the relationship between economic growth on the one hand and environmental protection on the other. It is a literature that is referred to as the environmental Kuznets literature. Why? Because there is a guy called Simon Kuznets, and that Mr. Kuznets received a Nobel Prize for the work that he has done on the relationship between economic growth, economic development on the one hand, and income inequality. And you know, people have been started to wonder what is in fact the relationship between, on the one hand, economic development, and on the other hand, environmental quality. And the story is a little bit like this. If you would have a country that has, let's say, zero industry, zero economic development, and it is in a natural state, then logically, the environmental quality is very high and there is no environmental pollution, logic. So you could say that in the beginning of a development, let's say we now start an industrialization, and as a result of growing industry, of course, income levels in a country are growing. What would you see? That logically in the beginning, a line is going up. So you see that the more that you are increasing income levels, the more that GDP in a country is increasing, the more that pollution levels also increase. And generally, that is also what you see. But now comes the interesting point. The point is this. After a while, you see an interesting development that after, let's say, income levels have been increasing, and you see also this increasing pollution level, what do you see? You see that at some moment it changes. And in other words, the result is you get an inverted U-curve. What does that mean? It means that if here at some moment the income levels still increase, you get more economic development, higher GDP, that at some moment you see the pollution levels going down. Now that is of course something remarkable and surprising, and there are a lot of explanations for that. One of the explanations is of course that when a society is first developing, they have industry. Industry is heavily polluting. And it may be that after a while, after your first initial development, that then the population has a different demand. And that then, of course, also the sectors in which you are active in a country will change. You will no longer be active only in industry, but you will be more active, for example, in the services sector. You go to banking, you go to financial services, you go to all kinds of different areas, not necessarily producing pollution as with industry. So let's say that that transformation, which is a normal development in economic growth, may to some extent explain why pollution levels are going down. Another important element is, of course, also the preferences of the population. You know, in the beginning, when you as a population have a very low level of development and you have poverty, your first need is food. Look, for example, in Africa, the first demand there is food. We want safety, we want to be able to eat, and we want to have food security, that our food is on the table every day. But once these primary needs are met, after a while, a population will also look around itself and will say, hey, but I am also interested in the quality of my rivers. I'm interested in the quality of the water and the quality of the air. You see, that would mean that the population then comes at this point of the Kuznets curve where they demand more interventions to reduce the environmental pollution. So let's say that changing preferences of the population could also explain why then the pollution levels are going down. If you want an illustration of that, look at a country not so far from you, China. You know, China typically had a very strong evolution in industrialization. As you know, since Deng Xiaoping, 1978, there has been a huge leap forwards towards industrialization and economic growth. And they have been enormously successful. But of course, what do you see now? If you are in Beijing, and I know many of you were, you look around you, you see 20 million people, you see enormous traffic, and you see people with a lot of wealth. But these people cannot breathe normal, high quality air. There is huge smoke, there is huge pollution. And as a result, these Chinese are now also demanding that the government would make environmental protection the #1 priority. And so that also changed the whole story. So what does it mean? It means that this environmental Kuznets curve implies that, yes, in the beginning of economic development, more economic growth means higher pollution, but that at some moments you get more economic growth and your pollution levels start coming down. But now, mark you could make the mistake from this environmental Kuznets curve of saying, apparently the only thing that a country needs to do is to have economic development. And as we grow economically, then environmental protection will automatically come. And dear friends from Indonesia, this was inter alia the mistake that the World Bank made in the 1970s and 1980s. They said literally to some developing countries, you know what? You should develop first, clean up later. And of course, what they were assuming is that as long as you have economic development, that as a result of this Kuznets curve, that the pollution levels would automatically go down. Now that is of course wrong. Why? Well, there is nothing automatic in pollution levels going down. How do we know that? Well, there has been a very important empirical research inter alia by Michael Porter and co-authors who have been examining, Dan Esty was one of his co-authors, Daniel Esty from Yale University. They have been examining for more than 100 countries in the world over a larger period. What is on the one hand, evolution in economic growth, so GDP levels, and on the other hand, what are the quality indicators for environmental pollution? But they have added something very important. They have added institutional factors. How strong is in a particular country the rule of law? What is the quality of the regulation? And what have they seen? They have seen that only in countries where you had on the one hand economic growth, the pollution levels went down when there also was a strong legal infrastructure. In other words, you now understand the crucial point. This research by Esty and Porter shows that yes, there is an environmental Kuznets curve. In other words, if you have economic growth, after a while your pollution levels go down, but they don't go down automatically. Why do they go down? They go down because when your income levels and your GDP levels in a country are increasing, also your legal infrastructure is improving. And it is because of the improvement of the legal infrastructure, of the rule of law, of the institutions, that is the reason that the pollution levels were going down. That of course complies perfectly with the work of Nobel Prize winner Douglas North. Douglas North, who also said that what really matters for a country in economic growth is institutions. And so now we know that institutions also matter for environmental protection. In other words, what is the lesson from this environmental Kuznets curve story? The lesson is a very simple one, but important for you and me, being the law matters. Environmental law matters. It also means don't be afraid of economic development. Economic development should not necessarily lead to more pollution. It can even lead to lower pollution levels and better environmental quality, but only on the condition that you have a decent environmental infrastructure. In other words, that you have a good environmental law. So that is quite important, that you also can signal to a particular country. It should not be so that if you have economic development, that should necessarily endanger your environmental quality. No, but at the same time, you need to make sure that when you develop, that you also develop the institutional infrastructure and the rule of law in a country, and that you make a decent environmental law. And that's why I want to talk about that question. What then is a decent environmental law in a country? Well, I told you already that if you look at some developing countries, some better than others, we see, unfortunately, a large ineffectiveness of the environmental law. What is some of the explanation there? Some of the explanation is that developing countries very often have relied on donors, on legislation provided by colonial powers of the past. Now, this is something, when I talk to Indonesia, I'm always happy that I can say I am Belgian. I have nothing to do with what the Dutch have done in Indonesia. But all of you are exactly aware of the phenomenon that I am talking about. What am I talking about? I'm talking about a phenomenon that we call legal transplants. What does legal transplants mean? It means that, for example, an ancient colonial power, like, for example, France, would go to former colonies in Africa, in Benin, in Togo, in Senegal, you name it, and would transplant French legislation to a developing country in Africa. What we see in Indonesia very strongly is that there still is a strong influence of Dutch law. If you look at an Economic Crimes Act in Indonesia, it is a literal copy of the Dutch Economic Offences Act of 1952. And also, if you look at the whole domain of the criminal law, the KUHAP and the criminal procedure, to a large extent that was, at least in the past, strongly influenced by Dutch law. And for that reason, Indonesian scholars were also attentively following developments of what the Dutch Hoge Raad, Supreme Court, would decide. We saw the same in the environmental area. Basically, what happened is that institutions like the World Bank, IMF, and so had an attitude, I apologize because I do realize that I exaggerate a little bit, that they said all kinds of institutions that worked well in, for example, Europe and in America, will work well in developing countries as well. Examples. Increasingly, there was a use of so-called market-based instruments, economic instruments, emissions trading, environmental taxes. Increasingly, there was a use of environmental impact assessments, of complicated and refined environmental procedures, but also, for example, of decentralization, bringing powers to local authorities. And the ideas was often that since that worked well in the north, that may work well in the south as well. However, what we have seen is that, with a transplant of a legal institution, it is a little bit like with a transplant of an organ in the medical sphere. You know that a body can accept a transplanted organ or can reject the transplanted organ. And that has a lot to do with the fact, does it fit in the receiving body or not? And exactly the same we have very often seen also in developing countries, that sometimes there was a piece of legislation that worked well, maybe in the Netherlands, and that then was taken to another body, like Indonesian law, and that was inserted there. But sometimes we clearly saw a rejection. Now, interestingly, the rejection was not always explicit in the sense that the law would be abrogated. But what have we seen very often in developing countries, including in Indonesia, that the law simply was not applied. Now that is, I would almost call it a hidden rejection, because you still have the law, but you don't apply it. Take the examples, you know exactly what I talk about, in Indonesia, of environmental management acts. We made beautiful acts of 1982, 1997, but we both know that to a large extent, these acts remained a dead letter. Why was that so? Because, for example, this act of 1982, Environmental Management Act, was what we called an Environmental Framework Act. It had general principles, but all the details needed to be worked out in implementing orders. And as long as the implementing orders did not come, the law could not be applied. Now, again, this is a typical example, let's say such a framework act of something that in the Netherlands, in Germany, in the US may work well. But there, of course, you expect that there is a whole bureaucracy that then is able to make all these implementing orders. What we saw in the practice in Indonesia was that very often these acts were then simply not implemented. They were there, but they remained de facto a dead letter. And so this is an example of where you say we had an issue of transplant, but the law still existed formally, but the law was basically not applied. So you could say that the receiving body, Indonesian law, in a way rejected the transplant by simply not applying it. Of course, what also is an issue is enforcement and implementation. You know, people very often say we have in developing countries, including in Indonesia, we have a good legal system. The laws are good, but you also need to apply them. And sure, you know, enforcement and implementation is often very important. And we all know why in many developing countries, also in Latin America, also in Africa, the sometimes good legislation is not applied. It may be simply that there are lacking resources. By the end of the day, for a good implementation, for a good enforcement and monitoring, you need staff with high capacity. You also need a good participation of third parties, and the affected citizens, they need to have a willingness to report if there are violations. That is not always the case in developing countries. And of course, and I will talk more about this, you know, all of these beautiful laws made in the US and made in Europe, they all are made under the assumption that you have an administrative authority and that you have civil servants that are well paid and that work in the public interest and that are totally free of corruption. Now, we all know that that is in many developing countries, including Indonesia, that is a dream. Reality is often very different. And then, of course, you understand if you transplant legislation that is based on the assumption of a well-paid, highly qualified bureaucracy, free of corruption, you transplant that to a country where these conditions are not met, that it's not difficult to imagine that the legislation will not be practicable and will not be implemented. You know, it is for that reason that some people have said, especially in a law and economic scholarship, they have said, now, wait a moment. Yes, implementation, enforcement is an important problem, but there is more than that. There is also the issue that we have to look at the quality of the legislation, of the quality of the regulation. Is the regulation in the way that it is designed, in fact, suited for the particular developing country. And you know, there is an increasingly, according to me, interesting scholarship. And I want to talk to you a little bit about that, because that scholarship points at the fact that maybe developing countries need a different environmental law. And so what is optimal, for example, in the US or in the Netherlands, is maybe different than what would be optimal, for example, in Indonesia or in a country like Congo. Why? There are three different streams of literature that shed some light on that. And the first type of literature that I want to point at is a literature that says, listen, you have to start by taking into account the problem of limited governance capacities. What does it mean? Well, we all know that for an effective law to be implemented and to be governed, we also need the importance of the rule of law, and we need effective institutions that are able to implement the rule of law. I told you already that Douglas North, our Nobel Prize winner, showed us that institutions are crucial for a country and also for economic growth. Now, there has been a German law and economic scholar from the University of Hamburg who wrote, together with Bob Cooter from Berkeley, an interesting book, and the book is called Solomon's Knot. Solomon's Knot. And what the book is about is indeed on the question, how does it come that poor countries remain poor? What are some of the problems in poor countries, why they cannot get out of this poverty trap? And one of the things that Hans-Bert Schaefer is talking about is about the type of legislation made. Let me explain. You know, there are generally two types of instruments in legislation. What can we have? We have, on the one hand, what we call rules. What are rules? Rules are instruments whereby the legislator describes in a very detailed way what you have to do. That's a rule. There is no discussion possible. The legislator says, this is what you have to do. It is what we call a rule-based system. The alternative is that the legislator makes very broad, vague norms, and that either administrative authorities or judges apply them. How do we call that? We call it a standard system. Now, if you look at what would be a preferred system, a rule-based system or a standard-based system, you know, in the North, in Europe, in the US, many people praise a standard-based system and say, in legislation, we only have to set out the general principles, general broad principles, like in the Indonesian Environmental Management Act 1982. And then administrative authorities will implement, or the judge will, in case law, further decide what has to be done. Standard-based system. Because they say the advantage of a standard-based system is that you can have discretion. And with discretion, you have the possibility of applying the system much better in a detailed manner, taking into account the location-specific requirements. But now comes Schaefer. What Hans-Bert Schaefer says is, you know, such a standards-based system, which may be ideal, which may be the first best in developing countries, works well in the developed world where we come from in the North. But there is one important thing that you may not forget. It has to do with the concept of human capital. What does it mean? Schaefer says, applying the legislation via this system of discretion through standards requires a well-equipped administrative agency, bureaucracy, and requires high investments in human capital. And here comes the point of Schaefer. He says, in developing countries, the problem is often that human capital is lacking. We don't have an administrative staff, a bureaucracy, or a judiciary that has the possibility of applying the standard in a concrete, in a detailed manner. And so what Schaefer basically is saying, you should then maybe do something else. You should say, let us look at what the reality is in developing countries. If the reality in developing countries is that we lack human capital, then don't make legislation that can only work if you have a lot of human capital, because then you know that it may remain a dead letter. What would it mean? That maybe if you say we lack human capital for a detailed specific implementation, then maybe in a developing country, you should rely on a rule-based system. What does it mean? That you then make very precise, very concrete, specific rules in the legislation itself, so that everyone knows these are the rules that we need to comply with. So you see, what this scholarship says, and that is what I think is interesting, why I like this type of scholarship, is that they say, you know what is optimal? What is the best? Maybe in the north, may be different than what is best in the south. And you should therefore adapt your recommendations, taking into account the specific situation in the south. There is a second type of scholarship, which I also find very interesting, and that is focused on the issue that I already talked about, corruption. It is especially a British scholar, Anthony Ogus, who said the following. Ogus said, you know, there has been a lot of literature on the importance of fighting corruption by, for example, increasing transparency, accountability, making the system from inside better. And Susan Rose Ackerman also wrote thick books on corruption, explaining how we could fight that problem and how we could increase accountability of the bureaucracy. And so let's say that to an important extent, the remedy has been to try to fight corruption, also in developing countries. What Ogus is saying is, sure, that should still be done. That's important. Yet, if you look realistically, you have to say that that fight against corruption has not been very successful. And you know better what I talk about than I do. That in many countries for 25 years, we have been fighting the mafia hukum and I don't know what, you know, for so long. But to say that it has been a major success, well, you know, in some cases, maybe yes, but generally, systemic corruption still continues. Now, what is Ogus therefore saying? Ogus says, I'm not saying that you should accept corruption, of course not. You should still be fighting it. But what you should also do, you should try to design environmental law and your legislation in general in a way that it is less corruptible. What does he mean? He says, for example, if you choose your instruments, again, you see that there is less possibility for civil servants to intervene. This again is an important argument backing up what I said a minute ago. You don't want a system, for example, with standards where administrative authorities have a lot of discretion. If administrative authorities can decide on, for example, standards, emission standards, pollution standards in permits, then this opens the gate to administrative authorities being bribed by operators. If you fear that that may be the case, what do you do then? You decide in a rule-based system, in the legislation itself, these are the conditions that the operators have to comply with. And administrative authorities cannot deviate from that. So in your legislation itself, you reduce the discretionary power of those who might be corruptible. But it has more consequences, For example, as far as the choice of environmental instruments is concerned, you know, I told you World Bank and so they are very enthusiastic concerning what we call market-based instruments. They say you should no longer have what we call command and control instruments. In other words, rules that prescribe in a detailed way what an operator should do. No, you use, for example, emission trading. You use, for example, environmental taxation. You know, again, I think that sounds wonderful, but what August is saying, these systems may work well in an environment where you have a bureaucracy, human capital, very well developed, very well trained, high level, well paid, no need to be corrupted, that apply the system. But imagine that you do that, introducing, for example, an environmental taxation system in an environment that is corrupted, then what you're basically doing, you say that operators need to pay taxes to civil servants. That is instituting the possibility of passing money from operators to civil servants. That, in an environment where corruption is an endemic problem, is not a very smart idea. So again, dear friends, what that means is that basically the scholarship says you should, in your design of your environmental mechanisms, of your instrument choice, you should maybe have another choice of instruments for developing countries than for the developed world. Because the conditions for applying, let's say, the optimal mix of instruments in the developed world may be different than in the developing world. Third example of a scholarship where I think it may have important consequences for the development of environmental law in developing countries. The level of decision-making. You know, again, institutions like the World Bank and IMF have for a long time been promoting decentralization of decision-making. Does that make sense? Theoretically, yes. Why? You know, you say, if you grant, for example, the power to a local authority to set conditions in a permit, theoretically, that can have the advantage that the local authority knows best what the location-specific circumstances are. They know what is the pollution there, what is the surrounding area, what is the natural habitat, what is the whole ecosystem. And on that basis, because they have better information, let's say, on the local situation in Irian Jaya than a bureaucrat in Jakarta, it may be good that the local authority in Irian Jaya would set the permit conditions. That is the theory. And that is why, for a long time, both in theory and at the policy level, people have been saying decentralization of decision-making makes a lot of sense. Of course, what we have seen also in Indonesia, but also in other developing countries, is that in some cases, decentralization has had catastrophic consequences. It has often led to a situation where so-called local elites have grabbed the power. Local elites have been bribing the local authorities. For example, mining companies. Mining companies asking for deforestation of vast areas. You know exactly what I talk about in Sumatra and on other islands. And of course, many of these local mayors have a much too close relationship with those local elites, can easily be bribed. And as a result, we have seen that in many countries, the decentralization has led to decision-making in the interest of the local elites of economic development, and where, For example, mining permits have been granted much too easily. And so as a result of that, here again, you could say, well, if there is such a danger of a collusive relationship between economic operators and the local authorities, then there may be a danger that the local authorities are not making decisions in the public interest. If that is your fear, what you really want then is a decision-making at more a distance, where you say, I think that, for example, people at the central level, government authorities at the central level may be better able to make decisions in the public interest, to weigh the economic interest and the environmental interest, and then set efficient standards. Now, mark you, I am of course not saying that by shifting the powers to the central level, that automatically you have a guarantee that decisions will be made in the public interest. Also at the central level, problems of collusion and of corruption can arise. I am very well aware of that. But in general, you know, at the local level, where there is less control, less transparency, less accountability, for local elites, it is relatively easy to create this collusive relationship with the local authorities. And logically, a local authority will always have, you know, a sympathy and a loyalty towards the local industry because it creates socio-economic benefits. It creates employment for their citizens. So their natural feeling will be towards the promotion of economic activity in their region. And it is for that reason that sometimes it is better to make the decision-making a little bit more at distance. Now, you know, when you take all of this, what I have told you so far together, what are some of the consequences? Well, it basically means that this law and economic scholarship tells us we look in environmental law always for what is called mixes of instruments. You know, last year I wrote a book that is called Smart Mixes of Instruments. That is what we look for. And so we want a smart mix between the central level, decentral level, between economic instruments, other instruments. That is what we're looking for. And so what this scholarship that I'm talking about is basically telling us, the smart mix of instruments in the North, in the developed world, is probably different than what is a smart mix of instruments in the South. And this is quite important since, to a large extent, the whole literature and the policy development all came based on experiences from the North. But what the literature is telling us now, we can no longer assume that what worked well in the North will also work in the South. We have to take into account that the situation in the South is different and requires different instruments. What does it mean? For example, in environmental law, that in developing countries, we may need more precise rules, less standards, less discretion to administrative authorities. We may need precise rules to avoid collusion, avoid capture. We may need command and control instruments, precise instructions to operators by a legislator. No vague framework laws that still need an implementation that never comes. And maybe avoid all kinds of instruments that require a lot of human capital, like, for example, environmental impact assessment, very important, works well in the North, but requires a lot of human capital. Same story for environmental taxes or tradable emissions. Those are all economic instruments that require a transfer of money from operators to civil servants. If you are in an environment that might be corruptible, that might not be a very, very good idea. So those are, let's say, some of the lessons from at least the law and economics literature from recent insights, which I think provide us some interesting insights on what an effective environmental law for developing countries might be. I think also that this literature helps us better to explain why some of the environmental law that we made in developing countries did not work. And especially we can understand it if that simply was legislation that copied the rules that were applied in the North, in Europe. I want to add that this literature, law and economics literature, is in a way supported and supplemented by another type of literature that is what we call the law and development literature. Now, law and development is definitely a different stream of literature than law and economics, but quite interesting. Their policy recommendations go to a large extent in the same direction. For example, in this law and development literature, they point at the fact that it may be wrong to simply copy legislation from the North to the South. For one reason, in the South, in developing countries, you often work with systems of informal law. In the North, everything is written and formal law that is enforced by the state. In the South, for example, in Africa, to a large extent, we have non-state law, which plays an important role. So we have the same, of course, in Indonesia with adat law, that to a large extent still plays an important role, customary law. So what do we have? We have a combination of formal law and customary law. In other words, we often have a model of legal pluralism, also playing a role in environmental protection. But this is often something that is not taken into account in legal transplants, where you only take into account the formal legislation. So that is why the law and development literature says take into account the fact that very often there is a legal pluralistic situation, and that some things may not be arranged on paper in the formal law, but may be arranged in customary law. Now, the law and development literature has also paid a lot of attention to the phenomenon I talked to you about a bit earlier, phenomenon of the legal transplants. They have a little bit an ambivalent attitude towards the legal transplants. Why? Law and development literature is critical to legal transplants because very often transplants are somewhat imperialistic. What do we mean with that? Sometimes, you know, the former colonizer, like the French in Africa, the Dutch in Indonesia, or the English in Africa, they assume that their legislation is the best. And so they work often with a theory of lack. What does it mean? They go to a developing country and they say, hey, this country does not have environmental taxes, does not have emission trading. They lack something that we have, and that's wrong. Now, what law and development says is that in a way, that approach to the law of a developing country is offensive and humiliating. Because in that approach, you are assuming from the North that your law is by definition optimal, is better than what you see in a developing country. And you may completely neglect, for example, the fact that there is customary law, that there is legal pluralism. So as a starting point, law and development is a bit critical towards legal transplants. Does it mean that they completely reject the legal transplants? No. They say, of course, you know, the fact that you borrow from what worked in other countries is extremely useful. But the conditions are the following. It should not be imposed, it should be demanded. Let me explain. It should not be so that either World Bank or the US or other donors or the Netherlands says, this is law that worked well with us, so you need to have that as well. That is top-down imposition. That's of course wrong. What would be different is if a developing country, for example, Indonesia, asks in what we call a demand-driven way, goes to different countries and says, we look for a particular solution. For example, how can we increase the effectiveness of private enforcement in environmental law? We want to have more collective action. We want to have more victims that can sue polluters. What could Indonesia do? And then they could go to different countries and say, well, what are examples in, and why necessarily in the north? Look around you. What are examples, for example, in the Philippines, in China, in India, which may culturally be much closer to you than, for example, the US or the Netherlands. And you see then, if you look at examples of what worked in other countries, you can still say, okay, this is interesting because I see some best practices in different other countries. And then if you implement such an example, it would be demand-driven. The demand for different legislation would come from the developing country itself, rather than that it would be imposed by the North. And then, of course, you could also take into account the specificities of your own law. For example, that in your law, customary law, informal law plays an important role. You could take into account your own legal culture. In other words, like a good doctor would look whether the organ that is transplanted fits into the body that receives it, you could do the same when you do a legal transplant. You look whether the organ that you're going to take from another legal system fits into your body, the Indonesian legal system and its legal culture. And if that is the case, you have a better guarantee that it may work. In other words, if I come to a conclusion and I look a little bit at the stories that I have told you so far, I think that the conclusion in a couple of words is relatively easy. If you look at how you develop an effective environmental law and policy in a developing country, a balanced approach is necessary. We need to differentiate. I think the most important conclusion for me from the literature I discussed with you is a one-size-fits-all solution does not work. You cannot assume that what worked in the US will also work in Brazil or in Indonesia. Now, in that sense, the recommendations based on a closer look at the literature may be different than what we sometimes hear from the World Bank and from the IMF. But I think if you look at that in a more balanced way, you see that these insights from law and economics and from law and development tell us that it is important to take into account the cultural, legal, and institutional context within which environmental law and policy instruments function. And then you could basically say, if you do that, you can have a better explanation for the paradox with which I started. Remember, I said the paradox is many developing countries have a lot of environmental law. Still, environmental pollution is continuing at a rapid pace. How comes? And you know, if you look at this literature, to some extent, you can understand it, because that law is not fit for the specific situation in the developing country. And so the answer lays also there, that you need to look at, okay, what are the problems in my specific country? What are the limitations? Do I have corruption problems? Or what is the strength? Is my judiciary very strong? Is my legislator strong? And then I can use instruments that are better fit for the particular institutional and instrumental context within which the environmental law has to function. Dear friends, in Indonesia, I wanted to tell you that the things that I have been telling you, I have published a little bit about this. I'm just showing you this with two friends, Morag Goodwin and Francisca Weber. And we have published this in the Virginia International Law Journal. So if someone of you would be interested in reading a little bit more, because I, of course, could only highlight some of the main findings, and this is free on internet. If you Google it on internet, you get it for free. You can download it like that. There you find much more details on the stories that I have told you so far. I leave it at that, and I'm looking forward to discussing the things with you.
Thank you, Professor Michael Fowry, for of course very interesting issue. I wrote at least 2 principles that you already mentioned, that we should have a decent environmental structure, and we have 2 approaches for developing our legislation with a rule-based or standard-based. Here we have in the chat, if I may, you may look at the chat, one response from Sabri in English, and one response from Ibu Agatha. From Ibu Agatha, I would like to translate it in English, Professor Fowry. Ibu Agatha is a concern with the issue that actually we have in the view of Ibu Agatha, that Indonesia has a good environmental law. And she said that the problem is an implementation or enforcement. So as you mentioned before, Ibu Agatha also said that finally at the end, our environmental act to be a dead letter. Yeah, but she highlighted that the tension is always between environmental protection and economic interest. Yeah, so her question is how we measure a distance between economic interest and environmental interest. Yeah, that's the issue raised by Bu Agatha. Please, Professor Fowry, you may respond it.
Thank you very much, Pa Radian. I think Ibu Agatha asked a very good and very relevant question. Thank you very much, Ibu, for your questions. I know that in Indonesia, the problem of implementation and enforcement is extremely serious. You know, Ibu, what is one of the answers is that when you are in a country and you see, for example, that your administrative authorities are very weak because they do not accurately implement the law, one of the things that you could then do is that you say, okay, you know, if my legislation is okay, but my administrative authorities do not implement, how about my judiciary? And I know, fortunately, that increasingly, especially at the lower levels in Indonesia, we start having some green judges. I know that ICEL and others, activists, have brought environmental lawsuits also in Indonesia, sometimes together with or on behalf of the government, in cases also of nature conservation breaches. And some of these cases have been successful. And so, you know, this illustrates a little bit the point I made earlier. Normally, you would not expect environmental policy to be made by the judiciary. But if you see that your judiciary is relatively stronger than, for example, implementing administrative authorities, then you can make use of the best of the institutions, like here, your public NGOs, your civil society, with ICEL and with other civil society actors are pretty strong in Indonesia. There are some judges that have a willingness, and also they realize that it's important to provide protection to the environment. And so then you see that if it's not going through the way of administrative orders, because there are difficulties, then use the strength of the civil societies and the NGOs together with the judiciary. And then you can make small steps. Ibu, I do realize those are small steps, but it are important steps. You know, I come in Indonesia now 30 years. I think 1990 was the first time. And I am optimistic. I see that things are changing. If I now see that judges are ordering operators, polluters, to restitution and to restoration, 30 years, we would not have thought that that would be possible. So you see, there are developments in Indonesia in the right direction that I consider important. Second, yes, sometimes environmental protection is under threat because of economic interests.
Yeah.
And you know, the whole question of environmental protection is indeed, how do we balance economic and environmental interests? But you know what an important point is? This guy whom I talked about from Harvard, this guy, Michael Porter. You know, this Porter wrote a couple of important books. And what he showed, and this has become known in the literature as the Porter hypothesis, Michael Porter said that if you as a company invest in environmental protection, this will not only lead to environmental protection, but also more profits to you. In other words, you will do well by doing good. And you know, this is not only theory, but also empirically proven that it works. Now, how is that possible? Well, the story is this. If you need to comply with stringent environmental law, you need to innovate. So as a company, you're forced to innovate. But the nice thing from this innovation is the innovation does not only bring you compliance with environmental law, but also a higher efficiency in production. And so as a result, you often see that those companies that go greener and that comply with environmental law also financially do better. So I think, Ibu, that is an important answer also to industry. Look at the empirical evidence provided by Michael Porter that if you invest in environmental protection, there is no conflict between economic growth and environmental protection. You can go green and protect the environment at the same time. This is not only true for companies, it's also true for states. Which state in the US is economically the most successful? California. Which has the most stringent environmental legislation? California. In the literature, this is called the California effect. And again, it is provided as an example of the Porter effect, that we say, indeed, these companies in California, in Silicon Valley, and so they are forced to comply with very high environmental standards and therefore become more competitive also on the international market. Still, Ibu, I agree with you that by the end of the day, in concrete cases, authorities will have to draw a balance and then, for example, decide, okay, now we're going to fix an emission limit value, an emission standard, and compliance with the emission standard costs money. So there, some balancing needs to be done. And there, of course, what is quite important there, that this decision is made at a higher level, that you don't have these decisions made individually at the level of a licensing authorities, because that opens the road to corruption. But that you then have a decision-making about standards, about norms, you are the cement industry, this should be the quality of your wastewater. The BOD, the oxygen, the heavy metals, this is what I mean with a rule-based system that you make based on scientific information. You make clear rules by which operators have to comply, excluding also too much discretion of the administrative authorities. I hope, Ibu Akata, that I have somewhat answered your excellent question. Thank you for providing me the opportunity, Ibu Akata.
Thank you, Professor Faurie. Ibu Akata is a legislator at East Java Province. Yeah? Professor Faurie, if you may, in chat there is a response from Tifa Desni, yeah? Tifa Desni, written in English. If you may read it, and then please have a response.
Tifa from University Airlangga, is it?
Yes, please.
She says that most decision makers in the Global South tend to formulate economic policy at the expense of environmental safety. And this always starts with the local elites undermining the values of indigenous culture. I agree. She wonders if it's possible to initiate a proper legislation to protect the environment by first encouraging central decision-making to formulate a proper policy to protect indigenous people's rights, which will in turn actually support these indigenous people to promote their local values related to environmental preservation. Because in my opinion, when it comes to environmental preservation in Indonesia, it is very much tied to the issue of indigenous people protection as well. Ibu, I can only say I agree. This is an excellent point. And yes, you know, the whole difficulty, of course, is that sometimes the situation of the indigenous people is extremely double, ambiguous, in the sense that indigenous people, on the one hand, have an interest in protecting the environment. That may be clear. They want to protect the grounds where their ancestors were. These are often grounds that are considered sacred for all kinds of procedures. And so look on Bali. Sometimes it are communal lands, tribal, that belong not individually, but to the whole group. That is absolutely crucial. And there I think it's very important also from a socio-cultural perspective that is very high in protection. You know what the difficulty sometimes is? That some of these tribal people, some of the locals, may of course be employed as well in the mines or in the polluting activities. And that then creates, let's say, a conflict of interest to them, that on the one hand, they want to protect the land of their ancestors. On the other hand, they have socio-economic interest as well. And I think that precisely for that reason, it is important in order to avoid that they get in these conflicting situations, yes, that at the central level, you would have a proper protection precisely for the indigenous culture. I think this is a very good point. I absolutely agree with what you wrote there. Thank you very much for this excellent comment.
Yeah, thank you, Professor Faurie. The last issue from Pak Sapri, which is, I think, relevant to the theory Kuznets curve. Yeah, he said that after more than 20 years staying in my housing complex, suddenly the pollution coming from the river or big canal beside of my house, where the bad strong smell come. In terms of GDP, of course, better than comparing 20 years ago. So you may have a response. I think this is relevant to the Kuznets curve. In fact, that after 20 years increase GDP, but then environment under threat.
Of course, what he writes here in the chat, those are terrible problems, and those are often very sad. You know what you have? Here we have what we call temporal conflicts. So that you can say 20 years ago that there was no problem. I was there was a river around me, and as such, we lived happily together. And then suddenly, as you write here, 20 years later, you see that suddenly strong smell is coming and pollution is coming. And you know, this is something not only happening in Indonesia, I can tell you. Go to the Netherlands, go to Amsterdam. If you go from the Amsterdam to the sea, you have a whole area there of heavy industry, metal, iron industry. And there you have a beautiful little town close to the sea. But then there are huge emissions coming from industry there now. And there is even from the authorities research showing that there may be very negative health effects. You know, these people say exactly the same. We live here already 50 years. I have lived here my whole life. Everything was fine. And now suddenly, what do we see? We see that here, the pollution is suddenly increasing. And I agree with you. These are cases where we should agree. You know, Mr. Sabri, what I also find important, what your example shows, is that it is important to keep environmental permits updated. Because why does this often go wrong? On the one hand, you may have received a permit 20, 30 years ago, which is now totally outdated. So you received the right for all kind of heavy pollution. I think that that is really problematic. On the other hand, it may also be that you are in violation of your permit conditions and that is why the river is so smelling. You know, your example also shows that your environmental policy should not only be based on emissions, on what you put into the river, but also on the health consequences for the individuals. And now the example that you give, you live in an area which now after 20 years becomes heavily polluted, becomes smelling. So there are negative health consequences. Personally, I think that these consequences should be tackled by, on the one hand, improving the permit, but also through criminal law. Why? I think that if there are health consequences like smell, noise, which have highly negative impact for the citizens, that may constitute a violation of human rights. And that may potentially also violate your right to life, your right to health, and that could constitute an environmental crime, even a common crime. And that for that reason, irrespective of your license, there should be a possibility of having criminal liability as well. So there I quite agree again, Mr. Sabri, with the points that you were mentioning. Thanks for these excellent points.
Thank you, Professor Fauri. All participants, I have to say sorry. My apologies that not all questions that may respond in this forum, because we designed this public lecture as a 1-hour lecture. So maybe next in the future we have an occasion like this. So we will of course share the information to the public. Professor Faure, once again, as a coordinator of study program of Law and Development, it is an honor for us to have you as a visiting lecturer, visiting professor, and I hope that in the future we still have cooperation, and also, of course, you may come to Surabaya, to Indonesia, of course, after the end of COVID pandemic. Thank you very much for your willingness in this evening in Indonesia, in the afternoon in Belgium.
Thank you very much, Dr. Redian. Thank you very much, Dr. Rosa. I thank all the participants. I saw there were more than 50. It is wonderful for me to see all the Indonesian faces. I was very happy to have the opportunity to exchange views with you. You did me a great pleasure by attending. Thank you very much. Terima kasih.
Terima kasih. Stay safe, stay healthy.